Thank you, Mr. Goswami. President of this session, Mr. Umayr, Advocate, Supreme Court of Bangladesh. Mr. S.M. Goswami, Senior Advocate, Supreme Court of Bangladesh, Chairman, PIMS. Dr. George Victor, Chairman, SARC Mediators Forum. Dr. Shoshi Adhikari, Senior Advocate, Supreme Court of Nepal. Special guest, Ms. Madeline Kigmi, Chairman, Africa Asia Mediation Association. All of them have connected through online. Keynote speaker, Ms. Ishrat Hassan, Advocate Appellate Division, accredited mediator. She has really discussed it in a very lucid way to understand the Legal Aid Act, Amendment Act. Guest speaker, Ms. Shampa Basu, political analyst. Special guest, Mr. Sharif Mohammed Sanal Haq, Additional District and Session Judge, Shapkira. We have heard from him the latest amendments regarding the amendment in details. Distinguished guest participants, ladies and gentlemen. It's already 12 past, so good afternoon to all of you. At the very outset, I consider it a great honor and privilege for me to address before you as the chief guest on the workshop on exploring process of mediation and ADR under the Legal Aid Ordinance 2025, organized by Bangladesh International Mediation Society. Let me start by expressing my gratitude to everyone involved in organizing today's event. You have already heard about the subject matter in details. However, I would like to give some basic tips on the subject matter, very precisely. In modern world, alternative dispute resolution has become very popular as an alternative route for reaching a speedier and less expensive mode of settlement of disputes. It includes mediation, arbitration, negotiation, and conciliation. Most of the countries of the world are now adopting major mechanism and achieve success in reducing backlog cases and increasing access to justice for all. Hence, before it's too late, it is high time to adopt an effective alternative method to solve this problem of backlog cases in our country as well. What I believe that one of the most important solutions for the problem is effective introduction of the concept of ADR in our judicial system. ADR is not something new in this new concept in the subcontinent. In ancient India, the whole village by way of Gram Panchayat used to solve the problems of the villages, sitting together and mediating the problems faced by two parties. Likewise, rural Bangladesh has a long tradition of doing shalish in family matters or in minor disputes. In Islam, the Prophet Muhammad ﷺ has always asked Muslims to settle the disputes between their believer brothers amicably. A true Muslim does not nurture conflicts, but rather attempts to solve them. In that sense, we can say that the culture of alternative dispute resolution is older than any other legal instruments we have at our hand today. Nowadays, arbitration and mediation are the most popular ADR forms in the world. Arbitration is widely used to resolve trade and commerce disputes in both the private and public sector all over the world. It is considered to be more efficient process than litigation because it is quicker, less expensive, provides greater flexibility of process and procedure. And the strict evidentiary rules, however, are not applicable in arbitration proceedings. Now let me focus on international arbitration. This is arbitration between companies or individuals in different states including a provision for future disputes in a contract. The predominant system of rules in the UNCITRAL arbitration rules, as well as the United Nations Convention on Enforcement of Foreign Arbitral Awards, known as the Newer Convention. This treaty, known as the New Convention, which entered into force on 7 June 1959, where arbitration hours can be enforced in most countries, unlike traditional court judgments. Till then, over 150 countries have ratified the New York Convention. Bangladesh is a party to the New York Convention. In the early days after independence, arbitration in Bangladesh were governed by Arbitration Act 1940. In order to rectify shortcomings, the Bangladesh enacted the Arbitration Act 2001 based on the UNSWRITAL model law. However, it is in fact that arbitration in Bangladesh have entered the reputation of being as expensive and time-consuming, since the enforcement of arbitration award is not time-bound. As a result, arbitration and enforcement proceedings go on for years and years, leading to substantial rise in costs for the parties. Hence, I believe necessary amendments in Arbitration Act 2001 are urgently required to overcome this problem. Now, I will highlight some points on mediation. You all know that which is a process where a neutral and independent third person, a mediator, helps the parties in a dispute to reach their own solution. In the words of Professor Hasseldine, mediation as a voluntary process where a neutral mediator attempts to help the disputing parties to reach an agreement that is acceptable to both sides and will bring dispute to an early conclusion without going to court. In mediation, mediator does not decide who is right or wrong, but rather helps the parties to come to mutually acceptable agreement. In fact, mediator acts as a shuttle diplomat between the parties and exchanges offers and counteroffers between them. The beauty of mediation is that in mediation, each party has the opportunity to voice their own point of view. They do not take sides. The parties have ultimate control over the outcome of mediation. It is simple, flexible, and time-bound. Also, the procedure is speedy, efficient, cheaper, and confidential. With extremely backlogged courts with over 45 lakhs cases pending in courts, Bangladesh suffers from a severely overburdened legal system. That is why we need to make the ADS system part and parcel of our judiciary. There are a number of legislations in Bangladesh that have specifically provided the provisions relating to ADR, particularly mediation and arbitration in civil matters, which are the Contracts Act, the Code of Civil Procedure 1908, Muslim Family Laws Ordinance, Family Courts Ordinance, Arbitration Act, Authoring Adalat Ain, Income Tax Ordinance 1984, Value Added Tax, Customs Act, Conciliation of Disputes, Board Act, Village Courts Act, Labor Act, EPZ Trade Union, Industrial Relation Act, Real Estate Development and Management Act, Legal Aid Act 2000, etc. In Bangladesh, the legislature has incorporated mediation and arbitration provision into the Code of Civil Procedure by way of amendments in section 89A to 89E of the Code in the year of 2003. The amended Act 2003 introduces court-based mediation and arbitration as an integral part of the civil proceedings in Bangladesh. However, at that time, it was the discretionary power of the court to explore the scope of mediation. Later on, the Act went through another amendment in 2006 that introduced the provision of mediation even at appellate stage. The code was amended in 2012 that made the mediation system mandatory in civil proceedings. It was again amended in 2017 that made provision to refer the dispute or disputes to the concerned legal aid officer. Now we have Legal Aid Act 2000, Ordinance 2025. Also in criminal jurisdiction, ADR has not yet widely introduced in Bangladesh. In section 345 of the Code of Criminal Procedure, there is some provision for compromise in the compoundable offences. So we have limited scope for compromise in criminal litigation in Bangladesh as well. Now, I will highlight something on online dispute resolution, which Ms. Madeline Kami has already discussed a little bit, that this system actually grown up in the COVID-19 pandemic. Since 2020, due to pandemic, whole world was in crisis, especially at the time of Western countries are increasing using different forms of technology and online dispute resolution platform for mediation and arbitration, which allow the parties to negotiate remotely, maintaining social distancing by virtually using smartphone, tablet, computer, or other similar technology. Practically from any location, that practice is still going on, so we need to take necessary steps about online dispute resolution to be effective in our country as well. Our economy is developing rapidly, brings this business into close contact with the outside world. Many foreign companies are now investing in Bangladesh. Therefore, effective steps towards alternate dispute resolution is needed in Bangladesh, an investment-oriented country. And that's why I always advocate for establishing an international mediation academy for dispute resolution in Bangladesh. And also I think it is high time for Bangladesh to be a signatory of Singapore Convention that was speaking by, I think, Shashi Adhikari. She was also feeling the need of signing the Singapore Convention in Nepal. The United Nations General Assembly 2018, it is known as the Singapore Convention on Mediation. The Singapore Convention will provide a more effective way of enforcing mediated settlement of corporate disputes involving businesses in Bangladesh and other signatory countries. Till date, the convention has 57 signatories, including India, Sri Lanka, Maldives, Turkey, Korea, Malaysia, Saudi Arabia, China, USA, and other countries. Singapore Convention ultimately aims to facilitate international trade and commerce by rendering mediation efficient and entrusted method for solving cross-border disputes alongside with arbitration and litigation. Regarding ADR, our former late lamented Honorable Chief Justice of Bangladesh, Honorable Justice Mustafa Kamal said, ADR is a non-formal settlement of legal and judicial disputes as a means of disposing of cases quickly and inexpensive. It is not a panacea for all evils, but an alternative to a speedier and less expensive mode of settlement of disputes. It is voluntary and cooperative way out of impasse. We know that judiciary Bangladesh was overburdened with millions of cases, and the number is mounting day by day, with institution of fresh cases due to number of factors including inadequate number of judges in terms of pending cases, procedural formality and complexity, poor logistic support, and corruption are the main reasons for backlog of cases in our country. In this backdrop, we can easily understand the importance of promoting ADR in our judiciary to reduce the huge backlog of cases. In the famous words of US President Abraham Lincoln, emphasizing the profound significance of ADR, said that discourage litigation, persuade your neighbors to compromise whenever you can, point out that the nominal winner is often a real loser in fees, expenses, and waste of time. Considering the huge workload of cases, we should encourage litigant people to go for mediation or arbitration, not for litigation. Rather litigation should be the last resort. My suggestion is that three organs of the state, executive, legislative, and judiciary, should work shoulder to shoulder to make ADR a popular way forward to achieve United Nations SDG 16. I believe that by introducing mediation and arbitration successfully in our judicial system, we will be able to solve this problem and open the door of justice to all by implementing the theme, mediate or arbitrate. do not litigate. There's a saying that justice delayed is justice denied, and also Martin Luther King said, injustice anywhere is a threat to justice everywhere. Injustice hurried, justice worried. So we have to find a middle way to solve this problem. And I trust that, considering the huge backlog of cases, mediation is the best possible option to overcome this situation, to ensure justice for all. In my opinion, to make the ADR mechanism effective in Bangladesh, certain necessary steps need to be taken. That is, the judges and lawyers should be properly trained up. Public awareness should have to be made to promote the ADR system. Third, a statutory body should be incorporated for formulating rules, planning, and monitoring the whole ADR system. That is, a commission for alternative dispute resolution. Positive impression should have to be created among the lawyers regarding ADR to ensure the independence of judiciary and transparency of prosecution. Further, corruption should have to be removed or at least minimized from all sectors to achieve best result for ADR and ensure justice for all. ADR to be made mandatory in certain cases, which already we have started by legal aid ordinance. Finally, integrating ADR in the legal education. Another problem is there is no mediation law in Bangladesh. However, in our neighboring countries like India, Nepal, Sri Lanka, they have mediation laws. And I think a mediation act should be enacted in our country, like the neighboring countries, that would significantly reduce the number of cases and burden of courts. Now let me highlight something about Legal Aid Amendment Act Ordinance 2025, which all we know that came into effect on 1st July 2025. The newly enacted ordinance introduced both pre-case and post-case mediation, either physically or virtually, by mutual compromise. The most crucial part of this ordinance is its schedule, which incorporates mandatory pre-case mediation in matters of family disputes, negotiable instruments, rent control, dowry, violence, domestic violence, among others. So, you have already heard about a lot of things about the new act from the keynote speaker, Ishrat Hussain, and from Sharif Mohammed Sanaul Haq, the additional district session judge. So I better skip this topic. So, some suggestions to promote ADR. The issue of lack of knowledge of lawyers are easily encountered by Bangladesh Bar Council. They can create a training certification program for lawyers on ADR, and they can also integrate a topic of ADR in bar examinations. For the new generation of lawyers, a subject of ADR can be added to their LLB program in universities of Bangladesh, like India, where ADR has been added as a subject in the undergraduate program under many legal schools and universities. A system of performance-based fees can be introduced for ADR so that lawyers do not think ADR is not worthy and advise the clients about it. If this is done successfully, it will mean lawyers will be trained in the field of ADR. So whenever one corporation goes into a contract with another corporation, of course they seek a lawyer's advice, and since the lawyers of the new generation hold knowledge of ADR, they are likely to advise their clients to add an ADR clause to the contract, thus further promoting the system. Lastly, applying ADR in Bangladesh also upholds the Constitution of Bangladesh, the preamble of Bangladesh Constitution, which says about the Bangladesh believes in the rule of law and access to justice for all the citizens. Moreover, Article 27 of Bangladesh Constitution ensures equality before law, and Article 35 mentions that in respect of trial and punishment, both can be safeguarded via ADR system. Peacemaker Kenneth Clark, founder founder of Mediation Beyond Borders International, indicates that without this order, no new order world is created. Likewise, the legal system of Bangladesh has already gone through a lot of issues. Now it is time to heal it by proper integration of ADR, securing the future. According to Ministry of Law, Justice and Parliamentary Affairs, disposing of over a million cases pending with the courts in Bangladesh, it will take at least 86 years if no new cases are filed. These pending cases are not only making the litigant public suffer, but also cause loss to the state. So you can understand the importance of ADR in our judicial system. Judicial system may collapse unless the remedial steps are taken immediately. Online, Bangladesh International Mediation Society to arrange such a fruitful workshop on ADR. I would also like to express my gratitude to the BIMS for their continuous support to promote ADR in Bangladesh. And especially, I'm delighted to know that some of the trained mediators, they already are involved in the United Nations Human Rights Commission. This is a big news for all of us. And already Mr. Goswami has declared that there is a 6-story building is going to be constructed in Paharpur, Nawabgarh Jilla, the Community Mediation Center. So it's a great news for all of us. BIMS is doing a great job. So I'd like to express my gratitude to the BIMS for their continued support to promote ADR in Bangladesh. Special thanks to Mr. S.M. Goswami for his contribution in the legal field of ADR. In fact, I call him the torch bearer of mediation in Bangladesh. I wish BIMS all the success in the coming days. I hope that all of you have enjoyed the workshop. Long live BIMS. Once again, thank you for listening to me with great patience. Best wishes for all of you. Thank you.